In a criminal case, is the defendant's right to a public trial under the Constitution absolute? That was the question in the case of the closed courtroom. In this case, the defendant was tried on charges of first-degree rape and sexual contact involving a child. The trial judge, on his own initiative and without a pre-closure hearing, closed the courtroom during the victim's testimony, which took about 15 minutes. The victim was 7 years old at the time of the incident and was 8 at the time of trial. Before the trial started, the judge informed a newspaper reporter that he intended to close the courtroom during the child's testimony. The only people left in the courtroom after closure were the jury, one of the victim's adoptive parents, an expert witness, the defendant, his attorney, and court staff. The defendant was convicted on the charges, and after the trial, the state moved to supplement the record with reasons why the courtroom had been closed. The defendant appealed, arguing his right to a public trial under the Sixth Amendment was violated and that he should have a new trial. How would you decide the case? Does a defendant have a right to have the public present in a courtroom? We'll be back in a moment to answer that question. Is a defendant's right to a public trial under the Sixth Amendment to the Constitution absolute? No, said the South Dakota Supreme Court. In general, courts conduct public trials for the benefit of the accused. The public may see that he's fairly dealt with and not unjustly condemned. The presence of interested spectators keep the jurors keenly alive to their sense of responsibility and to the importance of their functions. However, the right to a public trial is not absolute under the holdings of the United States Supreme Court, and in rare cases, a balance of interests must be struck before the open public trial is closed. In this case, before the appeal was taken, the trial court recognized it had made a mistake by not having a pre-closure hearing and placed on the record that the child was developmentally delayed, had hearing problems, had been repeatedly subjected to abuse and removal from her parents' custody until her parents' parental rights were terminated, and her adoptive father had testified it would be traumatic for the child to testify. On appeal, the court found that the trial judge made adequate findings which demonstrated an overriding interest that was no broader than necessary to close the courtroom to the public during the child's testimony. The defendant's conviction was affirmed. Remember, it's a matter of law.